item number 5 and 6 may be taken up after all the items in part 1, or if necessary, even after part 2.
Okay, let's see. We'll make a time being matter then. Isn't it? Who's the counsel for the, yes, Siraj Paxwala, huh? We'll make a time being matter.
My Lord, in respect of item number 5 of part 2, this is a fixed matter, my Lord. Even though it is not proper for me to make a mention, last night Mr. F. Langley, the counsel for the petitioners, had informed me that today he had some personal difficulty due to he has to attend the funeral service. And I was under the impression that his junior will be here to make a
No,
mention.
someone should be there. He has how many?
And
3 juniors.
we have spoke last night to fix the matter for this Thursday.
Okay, during this week, Thursday. No need to pass any order, I'll just note.
For motion, item number 1.
May it please Your Honor, Lordship. This is a petition filed under 226, challenging the circus notice, Your Lordship. That is
What's
page
wrong with
number
that?
45. Page number 45, Your Lordship.
Yes.
Married Lordship. Whereas list of encroachers at in the Steel Growth Center, Longmall had been submitted by Commerce and Industries Department to the competent authority, and it had revealed that you had encroached upon public land. And whereas the same is prohibited by Section 3 of the Mizoram Prevention of Government Land Encroachment Act 2001, and you are liable to eviction, including forfeiture of any construction, such as buildings, crops, or other products raised on such land, as per Section 7 of the said Act. Now, therefore, I, Engineer Larshad Puya, IAS, District Revenue Officer, hereby call upon you to so cause on 9 June 2025 from 10:30 a.m. onwards in my office chamber as to why I should not proceed against you according to the relevant sections of the Formation Act. Also, the main reason is that this so-called notice was issued without any legal sanction, Your Lordship.
So let's see Section 3.
Section 3, Lordship.
Under
That is-
Section 3, isn't it?
Yes.
Section 3.
Page number 51, Lordship. I'm sorry, yes, Lordship, page number 51. And the relevant portion is as page number 52. Prohibition of encroachment of government land. No person shall encroach or occupy any government land without the permission of the government. And the thing is that, Your Lordship, the relevant portion is now, Your Lordship,
Who is the competent authority
yes, Your Lordship,
to
that
pass
is
the
thing.
order?
That is the thing. The competent authority is a revenue officer, not a district revenue officer. And Your Lordship, the specified
Where?
para for that particular government is that page number 12, Your Lordship. May I kindly take you to page number 12 of my petition,
12.
Lordship? Page number 12, Your Lordship. If Your Lordship allows me to read out para number 5 onwards, Your Lordship.
Page number
Page number 12 of the
12.
petition.
So let's see, you can see as per Section 9 of the Act. So
Lordship.
let's see, we have already looked at the Act. So tell me
Lordship.
from the Act, isn't it?
Section 9, Your Lordship.
Section 9. So what is Section 9?
Section 9 is at page number 53, Lordship. Prior notice to be given to persons in unauthorized occupation before taking proceedings under Section 5, Section 7, or Section 8. The revenue officer shall cause to be served on the person reported to be in unauthorized occupation of the property of the government, a notice specifying the land so occupied and calling upon him to so cause on a certain date as to why he should not be proceeded against under Section 5, Section 7, or
So
Section
it is
8.
the revenue officer.
Revenue
who has to do-
officer.
Who is the revenue
Lordship.
officer?
Page number 51, Your Lordship.
Definition?
Page number 51.
District Revenue Officer is the Deputy Commissioner.
Deputy
it's
Commissioner.
Deputy Commissioner will be the appellate
Appellate
authority.
authority.
So G is the
G is
Revenue
revenue
Officer.
officer.
An
Revenue-
officer appointed or designated as, who's this thing? So is there any revenue officer appointed?
In my knowledge, Your Lordship, there may not be such specific appointment, but it may be.
Or designated as revenue officer? Who is
Lordship.
designated?
I cannot answer that particular question, Your Lordship. But the thing is that it is the revenue officer who shall issue such kind of notice. And the district revenue officer, as per section 2, clause A, is the appellate authority. If I'm not accepted, if I'm agreeing with the order of the revenue officer, I have to prefer the appeal before the district revenue officer, which is the deputy commissioner, Your Lordship. So
Who will be the district revenue officer, the revenue officer then? Anyway, this thing will have to inform us, isn't it?
Lordship,
But find out, is there a revenue officer appointed, someone designated as revenue officer?
Lordship,
Someone must be in the deputy commissioner's office only, or maybe from the, this thing,
Lordship,
directorate of, from the directorate side, maybe there's a revenue officer.
Lordship.
Anyways, we'll issue notice.
Lordship.
I heard Mr. T. Lalnunciama, learned counsel for the petitioner, who has filed the instant petition under Article 226 of the Constitution of India for issuance of the appropriate writ to the respondents and for setting aside the impugned show cause notice.
Lordship, not setting aside, my
Then-
limited prayer is this so-called notice is not bound upon the petitioners, Your Lordship.
So, by stating that, so the show cause notice, if he doesn't have the power, you'll have to set aside, isn't it? By point. So, what do you want? Let's see your prayer part
Lordship, my prayer is at
in the petition.
page
What is
number
your prayer?
16, Lordship.
You're challenging the show cause notice, and then you're saying you don't want it to set aside to stay the operation. Is it?
Lordship,
No.
not applicable in binding upon the petitioners. The so-called notice is not applicable in binding upon the petitioners. And apart from that, Your Lordship, the
So
stay of
so then it has to be set aside, isn't it? If it's not binding, you're challenging the authority who
Lordship.
issued the show cause notice. So obviously, if you're challenging the authority who doesn't have the authority,
that is somehow implied, Your Lordship.
then it has to be set aside if he doesn't have the authority.
Lordship.
Otherwise, if we let it stay without setting it, then what? Anyways, who has challenged the show cause notice dated 23rd May 2025, passed by the Deputy Commissioner, Aizawl District, Aizawl. Regarding the encroachment of the Industrial Growth Center, Luangmal, Aizawl against the petitioners. Full stop. The Learned Counsel submits that since the Deputy Commissioner is the appellate authority as per the Mizoram, within brackets, Prevention of Government Land Encroachment, close bracket, Act, 2001, open bracket will be from prevention. Okay, the Mizoram, open bracket, prevention, then encroachment, close bracket, Act 12/2001. He is not the competent authority to issue the said show cause notice under Section 3 of the said Act. Then a new para notice be issued to the respondents. Yes, Mrs. Mary L. Kyangte, learned government advocate, accepts notice on behalf of the state respondents. State respondent, full stop, no need to issue formal notice. Requisite copies of the writ petition to be duly furnished to the learned government advocate. List after 2 weeks.
Lordship, may I kindly pray the operation of this so-called notice, Your Lordship?
No.
Stay of
Oh,
operation
stay,
of lawsuit.
okay. List after 2 weeks. In the meantime, the said impugned order is to be stayed till the next date of listing.
Much obliged, Your Lordship.
Rather than staying the impugned order, may I be allowed to take instructions within 2 days?
Okay, we'll list it after 1 week. List after 1 week. Okay, then in the
Without-
meantime, we can stay, then you can get whatever instructions. Okay. So
Obliged, Your
it's stay till the next date of listing, so by that time.
Much obliged.
For omission, items 2 and 3.
Yes, the contempt.
Yes.
Huh.
May it pleases your lordship? My case is that I am the owner of two landed properties located at Bairabi, Kolosip district, covered under periodic pass number 58 of 2025 and 2005 and 59 of 2005. The respondent number 2 has undertaken the construction of an approach road within my lands, for which I was not given any rental compensation or any acquisition compensation, my lord. Being aggrieved, I filed the writ petition number 148 of 2019, for which the Honorable Court, Guwahati High Court of Aizawl Bench was pleased and satisfied to pass the order dated 19/3/2020, which is annexed at page number 11, annexion number 1.
Okay, let's have a look. 11.
Yes, my lord. From page number 13, paragraph number 2, if I may kindly read, my lord. Page 13.
Just a second. Page 13 of the petition. This is show cause reply. How has this been placed? Contempt. This is the show cause reply. These are all, how many show cause replies are there?
There's two, my lord. There isn't any one.
Total
Show
of
cause
4, my
reply
lord.
dated 1st May 2023. Yes, page 13.
Yes, from paragraph number 2, if I may read. Mrs. Linda L. Fumble, the learned government advocate, submits that as per the affidavit filed by the state government, the claim of the petitioner cannot be ascertained unless a verification of the petitioner's land is undertaken. Mr. Ali Hussain, the learned counsel for the respondent number 2, submits that he has no objection to the prayer made by the petitioner's counsel. However, at the time of verification, the NF Railway should be represented in the verification team. In view of the consent of the parties, this court is of the view that a verification team should be constituted. Accordingly, the Secretary of the Government of Mizoram Land Revenue and Settlement shall constitute a verification team consisting of the District Collector cum Deputy Commissioner Kolosip or his representatives, the Deputy Chief Engineer Construction NF Railways Silchar Kachar Assam or his representatives, and the petitioner who shall verify the lands of the petitioner within a period of 1 month from the date of receipt of a copy of this order. The verification team consisting of the above persons shall verify whether the lands of the petitioners have been used by the respondent number 2 for constructing a road. If the answer to the above is
Okay,
found to
see,
be...
so what
Yes.
are the verification team? This is the order which you say
Yes,
has
my
been
lord.
not followed. So
Yes, there are...
whether the lands of the petitioner has been used by the respondent number 2. Okay.
Yes, my lord.
Then,
So,
if the answer,
if the answer to the above is found to be in the affirmative, the respondent number 2 shall immediately take a decision within 2 weeks from the date of the site verification as to whether they want to permanently acquire the lands. If the answer is in affirmative, they shall make a requisition to the respondent number 1 and 3 for acquisition of the lands. Thereafter, award shall be made as per the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013 within a further period of 2 months. In the event the respondent number 2 is not willing to acquire acquire the lands, the respondent number 2 shall stop using the petitioner's lands immediately. In the event, the respondent number 1 shall verify and assess the damage caused to the petitioner's land within a month from the decision taken by the respondent number 2, and the amount so computed by the respondent number 1 shall be paid by the respondent number 2 to the petitioners within a further period of 1 month from the date of the assessment made by the district collector cum deputy commissioner concerned. The writ petition is accordingly disposed of. Thereafter, my lord, verification team was constituted, and verification was done on four times, where it was found
Four
that
times.
yes, my lord.
In the presence of both the parties?
First was in the presence of all the parties. Second was without the presence of petitioner and respondent number 2. The third was in the absence of respondent number 2, and the fourth one was in the presence of all the parties, my lord.
So let's see the last one, fourth one.
That I have not annexed in my. I did not have the copy, so it was submitted by the respondent number 1 and 3, my lord. So after that, it has come to my knowledge that assessment for the compensation was made. So I filed an RTI, for which I have been given.
But when the last, this thing verification, see, as per the order of this court,
Yes,
all
ma'am.
the parties have to be present,
Yes,
isn't
my
it?
lord. Yes,
So
my lord.
finally, when the fourth verification was done, it was done in the presence of all the parties.
Yes, my lord.
4 of you, isn't it?
Yes.
That's as per this thing. So let's look at the last verification. Fourth,
It is not.
has it been filed in the show cause notice?
My lord, yes, my lord.
Yes, by respondent number 1, my lord.
Okay,
Yes.
show cause reply. Respondent number 1.
Yes.
When dated?
This, I'm coming. This is my lord.
At annexion number 7, page 27 of the show cause reply submitted by respondent number.
My lord, page 51 of my additional affidavit, my lord.
Wait, when was the show cause reply filed?
My lord, it was filed, my lord, the
By
additional
the-
affidavit filed, my lord,
By the
on
respondent number 1.
24 February 2025. Okay, yes, the petitioner, please continue. Let's see.
No, my lord, I was talking about the show cause reply submitted by respondent number 1.
Respondent number 1.
Yes, my
Okay. Dated?
The copy
It
in my.
will be the same.
Yes, the spot verification report is at page number 27, annexion number 7.
Wait, dated.
22, 2020.
See, we have to be on the same page, so let me find out which one are you referring to. See, from the date, it's very clear. It's dated what, respondent number 3. This is filed by respondent number 5, respondent number 3. Then again, and then the show cause reply by the respondent number 5. Then you're referring to a show cause reply
Reply by
dated,
respondent number 1.
dated,
Date,
from the date at least it can be. This is show cause reply dated 1st May 2023, filed by respondent number 3. Then the next one which I have is 24th February 2025, filed by respondent number 5. Then the other show cause reply which is available here is show cause reply filed by respondent number 5, and this is dated 27 September 2024. Then, this is the petition.
my copy has no dates in it, my lord, so the only
Who is the respondent number 1?
is the deputy commissioner come district collector.
Who is
my lord.
representing the deputy commissioner? How come it has no date? Then it's not available here. See, when it's registered, when it is filed, then the date when it was received will be there. Who is representing the deputy commissioner? This is very strange. Then we'll have to look at the orders of this court.
That is in our record also, my lord, our affidavit. That is, report is with our affidavit also. Page, type copy is page 39, additional affidavit. That report, my friend. my lord,
Okay. In your show cause reply filed on
additional affidavit, my lord, it was filed 24th February 2025.
24th February.
Yes, my lord.
You have a copy of that?
Yes, my lord.
Yes, my lord.
Huh. There, the fourth spot verification report is at page
37, Annexure
37,
K.
my lord, is, and
37.
typing is, my lord, on 39.
Yes, so let's see, please, what is the joint verification report when all the parties are present? This is the compliance of the judgment. Yes,
Yes, if I may read. Joint verification report. In pursuance to letter number WPC so-and-so, joint verification was held at land owned by Pu F. Lal Hung Liana at Bairabi, Kolasip district on 15 September 2021 at 11 a.m. During the verification, the following people, officials were present. Number one, Mr. Satya Prakash, representative of Deputy CE Construction and F Railways, who is the respondent number two. Number two, Pu Arlal Niloma, VCP. Number three, Pu Van Lal Ngaka, surveyor. Number four, Pu F Lal Hung Liana, landowner. As per the direction of Land Revenue and Settlement Letter number so-and-so, assessment of damage was carried out. The length of damage,
okay, let's see, this is in compliance with the judgment and order of the
yes,
court.
my lord.
It is?
Yes, the judgment and the order passed in WPC 148 has been complied with by the respondent number 1 and
So all
3.
the people who are to be present are here?
Yes, my lord.
Just cross-check, okay. Where's the judgment?
Judgment, my lord, is page, my
Wait,
lord,
so many,
page 13, my lord, of
yes,
the
wait, I'll just have a look. Body of the petition.
contemplation, page 13. my lord.
Secretary to the Government of Land and Revenue. Is he here? Verification team consisting of the district collector. So is the district collector here on this day? Or is representative of the district collector?
There is one surveyor, one surveyor is there.
So can we say the surveyor is the representative of the district collector? Northeast Railway? So we can presume that the surveyor, is it? Is
Yes,
the
my lord.
representative of the district collector? Is
Yes,
it?
my lord. Previously also
It was the surveyor.
the deputy, yes, the surveyor and sometimes the settlement officer was
Okay,
there.
fine,
so-
fine. So all the parties are present, huh? Then?
So it was found that two lands were measured. That is P Pata number 58 of 2005 and 59 of 2005, where it was found that damage caused to P Pata number 59 of 2005 was 1,200 square meter, and for P Pata number 58 of 2005, the damage measured was 18,000 square meter. So the representative of NF
Yes, this is where the main thing lies, huh?
Yes, my
Read
lord.
that,
The representative of NF Railway refused to sign in the assessment sheet because he claimed that the assessment was not mentioned in the notice and that he cannot take decision by himself on spot.
So this is the where the main thing lies. Now the representative. So we should have waited for the representative of the this thing to get the authority on the joint verification report. That was not done.
My lord, this was already done in the year 2021.
Oh.
The contempt petition was filed in 2023, my lord.
So what happened between this? This is a verification report. You can't.
Last line, my lord, landowner, my lord. Note, the matter is already submitted to PC Kolasip during the joint spot verification on December 2020. Therefore, I am not agree with the findings.
Therefore, I do not agree.
Yes, madam.
Who is it? This is the landowner who says this. Therefore, I am not agree with the findings of this note.
And before that,
This is who? Who's SDCCENOS?
This is for the
Yes.
respondent number 2, my lord.
yes, ma'am, to the railway person, ma'am.
No, but how can you just say you do not agree with this note?
Yes, ma'am. It is, my lord, initial verification was there, my lord, December 2020, my lord. So if my friend completed, then I can submit my papers.
That means you are unhappy with the judgment
No,
of
ma'am.
the.
No, ma'am.
Then
This
judgment is very simple.
Yes, ma'am. Judgment is very simple, madam.
Then how can you say you do
may-
not agree?
May I place before this, my case, my lord. My friend, my lord, initially they submit, my lord, this one thing, my lord, this, let's see, may, repeatedly, 2 times submitted, my lord. The petitioner is the owner of 2 land, my lord. 2 land, my lord. So.
So what is wrong with the
Yeah, yeah, yeah,
verification?
yes,
Damages there?
Yes, my lord, yes, my lord, yes, my lord. From my, if lordship take up my additional affidavit, my lord.
Yes, petitioner, have you finished? Let him, then you can rebuttal.
Okay, one more thing I would like to submit that it is that the assessment was done. So from the assessment, total compensation from the 2 lands was assessed and awarded to the petitioner, my lord, which is at page number 19 of my petition, annexion number 5. Page 19.
Yes.
So for the P Pata number 58 of 2005, the amount of compensation awarded as per the Right to Fair Compensation and in Land Acquisition Act 2013 was 48,42,000, and for P Pata number 59 of 2005 was 3,22,800, total of which amounts to 51,64,800 rupees in total, my lord. So that is the amount to be given by the respondent number 2, which the respondent number 1 and 3 have clearly complied with the order. So it rests upon the respondent number 2 whether he is to acquire or he is to vacate and pay the rental and damage compensation to me, my lord.
Okay. Now, in the writ petition,
My lord.
you are the petitioner.
Yes,
How
madam.
many petitioners are there?
Only one.
One.
One petitioner. Okay. F. Lal Hungliana.
Yes,
Now, the landed property which was measured, the LSCs,
Yes, my lord.
periodic pata, it belongs to whom?
Myself and my wife.
Wife was not party, my lord. in writ petition.
So now the wife, in the writ petition, we have to look at the writ petition
Yes,
and
my
see.
lord. Writ petition, my lord.
This thing, the writ petition, whether you have prayed for which LSC or which periodic pata.
My lord, this writ petition is another writ
Okay,
petition is
wait,
pending.
wait. Let her finish. She'll also have a copy. In your writ petition, you had mentioned which periodic pata?
Periodic Pata 58 of 2005 and 59 of 2005, my lord.
Okay, both of them.
Yes, my lord.
And in the judgment, it says it has to be both this thing.
Yes, my lord. Both the 58 and 59 of 2005.
Then if it's both, then you cannot say these are landowners covered by periodic passes, both of them, 2 of them. Okay, 501/801/10 and yes, it's 2, both of them. So in both of them, this is the verification report. Now, in this little note, the matter is already submitted to, So the only thing now is in the verification report, the representative of the NF Railways says that he cannot take the decision by himself. So you get instructions
No, my lord.
concerning
Yes,
this?
I'll take instruction, my lord, in this year. Before that,
Because this is this thing.
yes, my lord. Lordship, then if my friend completes, I'll say. Before that, your lordship may take up the writ petition, my lord. Writ petition is another.
No.
Just,
Contempt.
I'm coming, my lord. The writ,
What is your writ petition?
my,
Huh.
no, not my, her writ petition, my lord.
Okay, her writ petition,
petition,
copy.
I-
Copy is that?
I annex in my that writ petition, my copy, my lord.
Because, you see,
Yes, ma'am.
because when
I'm-
a coordinate bench of this court has
Yes, madam.
already
Yes, madam.
decided,
Yes, madam.
we cannot
Yes, madam.
change, and if you are unhappy, you will have to file a review or something.
Yes, madam.
Yes, where is your writ petition in?
I have filed another.
Show cause reply?
No, my lord.
Dated?
In another writ petition which is filed, my lord, I have annexed that the writ petition of my land friend.
You should have made it here in your show cause, this
Yes,
thing, reply, isn't it?
Yes, I have made a reply. It is clear in my.
You should have mentioned that in your show cause
Yes,
reply,
it-
because
yes.
I don't think the writ petition can be entertained at all,
Yes,
when the
madam.
matter has already been
Yes,
settled by a
yes,
coordinate
yes,
bench
madam.
of this court.
Yes, my lord. In paragraph 4, and 5 of my reply also I have mentioned, my lord. So before that, my lordship may take up this the writ petition filed by learned friend. my lord.
Oh, okay. Where's that page?
My lord, is another writ petition, my lord, which was filed by me, my lord. It was it is page, my lord, 26, my lord. Page 26. It starts from Annex A, page 21, my lord.
Page
Page, my lord, it starts from page 21, my lord.
21, huh?
21.
Which paragraph?
Relevant portion from page 25, my lord.
25. Huh.
Up.
Okay, no, it will be page 26.
25, your lordship may,
25 what, 25?
yes,
huh?
ma'am. Here, my lord, the petitioner is one, my lord.
Okay, so if you have some doubt concerning this, then you should file a review petition.
Yes, my lord. So-
Before the
and-
court who
yes, ma'am.
passed the judgment,
Yes,
not
yes.
a fresh writ
Yes,
petition.
my lord. Thereafter, lordship may turn page 26, my lord.
Yes.
My lord, this everything was, my lord, this misrepresenting by the writ petitioner, my lord, order was taken, my lord. Paragraph 2. The petitioner stated that he is the owner. He is the owner of landed property covered by periodic patta numbers so and so 58 and periodic patta number so and so 59 of 2005, both located Bhairavi so and so so and so. Lands belongs to the petitioner were purchased from so and so. It was purchased from so and so on 2018, my lord. 18, my lord. And my lord, and paragraph number 3, the petitioner is the responsibility, more particular responsible to NS Railway has constructed an approach road within the land of the petitioner for transportation of materials so and so so and so, that accordingly responsible to under the construction of the approach road within the petitioner's land without consent and without paying compensation as per law. As such, residual crops, trees were damaged part taking over land without following due procedure law. And thereafter, the paragraph 4, the petitioner thereafter approached the respondent authority for payment of adequate compensation toward damage caused upon his land. Being highly aggrieved with the action of the respondent, petitioner submit a representation on 15/9/2019. On the land was they purchased land was 2018, 29/10/2018, and my lord, this representative was submitted on 15/9/2019, and my lord, lordship may turn.
But you have not filed any review petition against the judgment? Now you're coming with the writ petition, how can that be done?
My lord, only thing is whether it is petitioner land or not. The petitioner land, it is verified, my lord. This, my lord, is ultimately in my.
Whether it's his land or not, but both the, this thing, periodic pattas are mentioned by this court, by its order dated 19/3.
But-
At that
but-
time, we should have objected.
But in my reply, additional affidavit reply, my lord, last page 58, my lord. Page 58, my lord. Lordship may.
Okay,
My lord,
then what you can do is you can file a review petition before the court who passed the order. And if that review petition is accepted, it's a different matter. You cannot file a fresh writ
my lord,
petition.
yeah,
challenging the
I understand, my lord. So lordship may turn page 58, my lord, annexer N. Statement and.
Because an order has already been
Yes,
passed
yes,
by a
yes,
coordinate
yes,
bench
madam.
of this
Yes,
court.
madam.
I'm not going to
Yes,
interfere.
madam.
Yes. So
Annexer
what,
N, page
58?
58, my lord, of my additional affidavit. Statement of land compensation in respect of so and so with in connection with WPC 148 2019. My lord, it was, my lord, in respect of the petitioner, my
But
lord.
what did you say before the trial court, when, before the learned court,
Yes.
when the matter was
Ye-
considered?
yes,
You
ma'am.
said, okay, we'll have a
Yes, my
spot
lord. Yes,
verification.
my lord,
All those should have been raised
My
at
lord,
that time.
my lord, this.
Now at this belated stage,
land
you
was not
come in-
verified, my lord. Land was different land. Land was not the petitioner land, my lord. This aggrieved party.
But the court
Yes,
had mentioned both the periodic
My lord-
passes.
my
At
lord,
that time, you should have said that it should be for one periodic pass.
I understand, but it was, my
then?
lord, lordship. My lord, only one thing, my lord, the, page 12 of the contempt petition.
Let's see the judgment. We have to see the judgment
Yes,
whether
yes,
there's
yes,
compliance. We're not
yes,
going
my
to
lord,
look
just
into
page
anything
12,
else.
my lord, page 12 of this order, or just order. my lord.
Okay, let's come back.
Yes, my lord.
One minute.
Second
Let me-
paragraph. The petitioner's case is that he is the owner. Petitioner case is that he is the owner covered by period Pattanam so and so and so.
Both.
It is
Then you
his
should have
statement.
objected at that time.
It is his statement, my lord. It is
Okay,
not done.
then the order of this court.
It is his not the court not directed to this only these others land also, my lord. It is only his statement, my lord. This land both land are his land. So the last.
Okay, so you have to file a review petition
Yes, ma'am. I'll file review petition.
to clarify
Yes, ma'am.
whether it has to be both.
Yes, ma'am. Because my lord is one.
So we'll wait for some time whether the review petition at this stage, again, it will be, whether it's going to be barred by, when was the order passed, dated? What were you doing all this time?
19/3/2020, my lord.
Ah,
2020, ma'am.
2020. After 5 years, that's anyway a headache now. So we'll give them some time.
Yes, ma'am.
Okay, because, yes, since there is, he submits that the landed property should belong to only the petitioner, while you have also admitted that it belongs to his wife. It's not in his name, isn't it? So we'll give him some time. We'll dispose of the contempt petition accordingly. And also, in view of this today's order, we will also dispose of the writ petition, because it's not appropriate to file a fresh writ petition
Yes, ma'am.
against an order that was passed by the coordinate bench of this court. Okay, accordingly, I'll pass the order later. Okay, both the contempt is adjourned. Okay, since the learned counsel, I'll just pass the order, heard Ms. So-and-so, Valentina, learned counsel for the petitioner, along with Mr. S.K. Medi, learned counsel for respondent number
5, ma'am.
5.
My final subject.
5 and
Joining Sankui, ma'am.
Baby Lalrinzali. How come both of you were applied?
My lord, initially they were appointed, my lord. Subsequently, when I filed writ petition, my lord, the honorable court filed an additional affidavit, my lord. Both are we are dealt.
Okay, along with Miss Baby, Mr. S.K. Medi and Miss Baby so-and-so, learned counsels for respondent number 5. So what do you have to say in this matter?
We already filed our short report.
What did you say in the short course reply?
Same.
Okay, along with the learned counsels for respondent number 5 submits that since there is no clarity in the said judgment and order dated
19/3/2020.
We are not, my lord, not this.
No, it's
questioning
not
the
clear.
judgment.
It's not clear. Because of that is you have protested, isn't it? Because the judgment and order does not mention the periodic passes, so that has to be clarified. Since
Ma'am,
They
then
they are
my-
not clear.
then my-
Since the learned court in the order dated 19/03/2020, passed in WPC number 148/2019, has not specified regarding the periodic passes which has to be verified, and submitted that the periodic pass number, which one belongs to the wife?
Wife, my lord, is
59 of
59,
2005.
59,
59 of
2005.
2005.
2005. It's not in the name of the petitioner. They would like to file a review petition for the learned court to specify the periodic pata which has to be verified
No, and
by
another
the
thing, also,
verification team.
another thing also there, my lord. My lord, the land was purchased 2018, my lord. And
All that you mentioned before the learned.
and
Supreme Court.
other thing, that may be reflected in the order also.
My lord, if I may submit one thing, from the judge, from the order dated 19/3/2020, page number 14, my lord. The order passed by this honorable court has clearly stated that the verification team consisting of the above persons shall verify whether the lands of the petitioner have been used by the respondent number 2 for
But it is
constructing.
of the petitioner.
Okay.
Okay, so there is some, it's not very clear, isn't it? When you yourself admitted that one of the land is not in the name of the petitioner, so I think that little clarity you should have mentioned before the court
Yes,
anyways.
only my humble submission, my
No,
lord.
all that in your review petition, you can mention whatever you want.
Yes,
Okay?
liberty.
What's the last sentence? And therefore pray that they may be given time, since they would like to file a review petition before the learned court.
My lord, I forgot to mention, in my writ petition 148 of 2019, I have annexed a sale letter, my lord.
Yes, my lord.
Okay, all that you, this thing, and he'll file a review petition, whatever clarity that's required, and then the court can decide, isn't it, sales letter, whatever. You can reply to that, those, on those grounds also. On hearing the submissions made by the learned counsels. Okay, now before that, we mentioned the learned counsel for the petitioner, in all fairness, also mentions that one of the site, this thing, periodic pata is in the name of the wife of the petitioner. She, however, submits that the learned court in writ petition so-and-so, okay, dated so-and-so, had mentioned that it is the periodic patas which have to be verified. This court, on considering the submissions made by the learned counsels for both the parties, find it appropriate if the respondent number 5 is given the chance to file a review petition. For clarity, which they wish to sort, which they wish to seek from the learned, from the court. Accordingly, the contempt petition is adjourned to enable the learned counsel for the respondents number 5 to take necessary steps.
My liberty, in place of sons, my liberty may be given. my lord.
No, we will adjourn
My lord, sons is given, it is written, my lord. In place of sons, my liberty may be given, my lord.
Okay, oh yes, liberty be given to so-and-so. Accordingly, list the matter after, make it 4 weeks. In the meantime, any development you can
My
inform.
lord, because holiday is coming, my lord, after, my lord, 2 months, my lord, because I will try, my lord.
Okay, after 2 months?
Yes, ma'am.
After 2 months.
And I can raise another. Point also.
Otherwise, if,
I understand, my lord, I understand.
so
Another point also, my lord, it was no objection was given 2015, my lord. And that time the road was there, my lord. And in 2018, it was purchased, my lord. And 2019, it was, my lord, the periodic patta, my lord. Immediately after 3
okay,
days, my lord.
My lord, the submission may be given in the review petition, my lord.
okay, we'll just mention here, because we cannot decide the
Yes, my lord,
contempt
yes,
at
that
the,
time, because
besides the ownership, we can say that, and also that the road,
yes, my lord.
okay, what, was purchased?
No objection was given by the village council, my lord, 2015, my lord.
That was from the village council,
And-
but no
and-
objection was not obtained from the landowners, my lord.
My lord, landowner.
So that may not be
By-
reflected, my
You
lord.
further submitted that no objection was already obtained from the village councils on,
My
in
lord,
the month,
2015, my lord.
in 2018,
15, my lord, 15.
15,
Yes, madam.
be clear,
6 February 2015, madam.
on 6 February
It was by the
2000.
2015, by the deputy
15.
commissioner. Yes, madam. By the office of the deputy commissioner, Kulasip, madam.
If my submission may also be reflected, my lord.
Yes, madam.
You see, all this you should have pointed
Madam,
out before the
yes, madam, but
court, instead of
no,
now at
court-
the stage
my-
you're
my- my
saying.
court may ask, madam, limited.
Okay, okay, in 2015, that date, okay, no objection was already obtained
From the deputy commissioner.
from the deputy commissioner. By the deputy, not the deputy, from the, it will be by the deputy commissioner,
Yes, madam. It
by
was
the deputy
issued, madam.
commissioner from the village council.
No, my lord, it is written like this, my lord. This is to state that the district administrator Kulasip does not have
Oh,
any
okay,
objection.
no objection was already obtained on so and so, okay, when the land, while the land was purchased.
No, not purchase, madam. Well, the construction, road construction, madam.
Okay, just leave it at that.
Yes, ma'am, yes,
Okay, like,
My lord,
whatever
if my
for the
submission may
review-
also be written, because they did not obtain any objection from us. No objection was not given
My
by
lord,
the
that time
landowners.
her land
That
was
was
not there, my
important,
lord.
that was
2018, my
important.
lord.
You leave that in the review petition. If, we'll have to see whether the review petition will be admitted or not.
Yes, ma'am.
Okay. If it is dismissed, then we will hear all that.
Yes, ma'am. Yes, ma'am. 2015,
Yes,
they
this
purchased
after-
2018 land, ma'am.
Okay, now in the main writ petition, we will dismiss the writ petition. Okay, on the grounds that this matter is already decided, whatever. I'll pass the order, I'll dismiss your writ petition.
Highly appreciated.
Item number 4.
I've given you copy.
Yes.
Highly appreciated.
Your Lordship, this matter was fixed for today for hearing and a potential disposal of the case. Look, this matter is involving the fundamental rights under Article 21 of the petitioner. And my lord, I would like to humbly submit that this matter has been pending for 2 years. And that is why some urgency has used there, Your Lordship. And Your Lordship, I also want to submit that this is a covered matter actually by the judgment passed by Your Lordship as well as other coordinate bench of this court. And my lord, Miss Mary was taking up this matter and she has just requested me just now.
Oh, so we cannot have, what is the matter about?
It's an
If it's covered
execution-
matter?
Yes, covered matter by the other cases, Your Lordship. My lord, Miss
So
Mary,
have you attached those, this thing, judgments?
my
If
lord,
you say it's
I'll be-
covered, then all the judgments where it is covered has to be,
Yes, my lord.
yeah, where is it?
Covered in the sense that, my lord, the stands. the
So it's
stand-
not covered. Covered in the sense means it's not actually covered.
It's just that in other cases, the petitions were children. Here, the petition is 24 years old. And on rooftop, electrocution occurred in the rooftop. So covered in
give
the
me
sense
those
that the
judgments.
similar,
So it's covered if
Yes,
it is,
yes, ma'am.
whether the age of the this thing, it's a different matter. Okay, so give me those judgments give a copy also. Okay, anyways, heard Mr.
Well, Miss Mary has requested that
Heard Mr. Jonathan L. Silo, learned counsel for the petitioner, who submits that this matter is a covered matter and he will be submitting the judgments passed by the coordinate bench of this court to show that the matter is a covered matter. Ms. Lalnun Louis, learned government advocate, appears on behalf of Ms. Mary El Kiante,
Yes,
who is
Lord.
taking up the matter and prayed for adjournment.
Ma'am,
Yes.
If
sorry,
the-
Your
if
Lordship,
the-
Miss Mary has requested that this matter may be fixed on the next Tuesday.
On the 24th of
Okay,
June, Your Lordship.
for
for this
adjournment and be fixed on
24th.
24th,
June.
6,
Yes, Your Lordship.
2025. Accordingly, list the matter on 24th, 6, 2025. Meanwhile, the learned counsel for the petitioner will furnish copies of the judgment wherein the matter is said to be covered. Yes.
Much obliged, Your Lordship.
Item 7.
Instead of wherein, whereby. Yes.
Yes, my lord, they have opened the
What
Respondents'
happened?
Council
Uh,
is reaction the other court. So may it be passed for the time being. May it be taken up after the other.
waiter, Caroline Kela Lungoipu is the one taking up the matter, is it?
Yes,
What is the case about?
this case is about the appointment of security guard at Khozol under the Department of Social Welfare, Women and Child Development. It is a simple matter. He was appointed and his appointment was reviewed.
Okay, then in the counter affidavit, what did they say?
Yes, there are some reasons. They
Okay.
have not much such reasons for
Okay,
considering.
we'll make it a time being matter. then.
Yes, then
Item 8.
Baby, please, Your Lordship. This is petition under 226. And Your Lordship,
Notice not complete?
yes, no ID card is returned, Lordship.
Then we'll wait for return of AD card,
No,
isn't it?
Lordship.
What is the address?
This is an
The
IT,
respondents?
Chaltam.
They all are here within the state, isn't it?
Lordship,
In
this
the
is an National Institute of Technology, NIT.
NIT. Address this way.
Page number 3,
Mizoram,
Lordship.
Mizoram.
Yes, Chaltam, all are Chaltam.
Then we'll wait for
Any
some
answer?
time.
The standing counsel is Mr. Zoram Chana. I also contacted him. I also saw him.
Okay, but was notice received on their behalf? No.
No, Lordship.
Then we'll have to wait, isn't it?
Lordship.
Heard Mr. T. Lal Nunsiama, learned counsel for the petitioner, who submits that AD card from the respondents is still awaited. In view of the above, list after 2 weeks.
Lordship. By the way, Lordship, may I make a simple prayer with regard to the stay of some proceedings, Lordship. Lordship, this is regarding, in fact, I have challenged some impugn order, and the relevant portion is at the Lordship page number 48B, Lordship. May I kindly take you, sorry, page number 49, Lordship. Page number 49. Page number 49. It's the communication. It's a communication made with me by the institute. And may I read, Lordship, this particular communications?
Yes,
This is email conversation. The date is January 29, 11:14 a.m., Lordship. And the first one is, Dear Dr. Mohanty, I am Dr. Mohanty, Lordship. Based on the complaint received, you are hereby informed to appear before the fact-finding committee on 29, the same day, Lordship, 29/1/2025, at the office of the Registrar, NIT Mizoram, at 5:15 p.m. At 5:15 p.m. And Lordship, in answering this message, down there, I write a message. Dear Professor Ajmal, can you please attach the complaint, what you have received? I need to go through it before appearing. And this is the same date, 11:24 a.m., Lordship. And on the same day, the Lordship, down there, dear sir, as requested by me in the trailing email, I have not received a copy of the complaint. Yet, that is the scheduled time. It seems to be a clear case of violation of the principle of natural justice. This is to state that the whole day I was not in a position to concentrate on my important assignments, working at the level of associate professor in the Institute of National Importance, that is NIT Mizoram. Again, it seems the complaint is false and prefabricated, and the act is a clear case of mental harassment to me. In these circumstances, I am not in a position to appear myself. I should not appear myself as intimated. This is for your information and necessary action, please. And I wrote this letter again, Your Lordship, in the same day. And the following page, Your Lordship. Dear Mohanty, the complaint cannot be shared with you over mail, as we need to protect the identity of the complainant. Institute cannot push our students to further troubles. The matter will be disclosed to you during the proceedings. Hence, once again, it is informed to appear before the committee members on 30/1/2025, 4 p.m. Non-compliance of this order shall be viewed seriously. Means 30th, it is postponed to 30th, 4 p.m. And down there, Your Lordship, dear Mohanty, please report at 5 p.m. instead of 4 p.m. Regards. 1 hour delay. And again, Your Lordship, down there, I made it to the director in IT. Dear sir, this is to bring to the notice of your good office the following, as per Professor Ajmal's email. Number 1, the complaint cannot be shared with me over mail, as we need to protect the identity of the complainant, but one can obtain it through an RTI. If this is the case, the complaint may be shared protecting the identity of the complainant. Number 2, the institute cannot push the student into further trouble. What kind of trouble is he talking about or expecting for? He has an earlier experience of it or what? In an institute like NIT Mizoram, how can a teacher trouble a student as a teacher usually puts his efforts into making the students learn the subjects well or do the research of the best of each kind for their better future career? Number 3, the matter will be disclosed to me during the proceeding. The institute should ideally give me enough time to prepare myself for the defense pertinent to complaint received. Who is the student and what is the complaint all about? I am not even aware of it till now, officially. Number 4, hence, once again, it is informed to appear before the committee members on 30/1/2025, 4 p.m. Yes, I am ready to attend. But do you feel that the committee members will be very impartial during the said meeting and will come out with a fair decision, ensuring the integrity of an employee? Number 5, non-compliance of this order shall be viewed seriously. Order. What is the meaning of the order in this email? Viewed seriously seems to be threatening. Do you feel that a registrar in charge has been authorized or empowered by the first statutes under NIT Act 2007 to order and threaten an employee in his official email communication in this manner? This makes me doubtful about his behavior with the students. Maybe students do not dare. Official email under communication in this manner. This makes me doubtful about his behavior with the students. Maybe students do not dare enough to write complaints against him, or no one provokes the student to act in that manner. In the usual case, an employee prefers to receive email communications very politely from an employee holding the said position. Having experience in receiving an email of this kind from a registrar in charge, I am in doubt whether to attend the meeting or not, as I am not aware of the planned conspiracy. Requesting your input and intervention in the said matter. Your reply email will certainly allow me to attend the said meeting at 5 p.m. rescheduled as per his email. This is to state that at this stage of my age and career, I am in need of mental peace, working towards benefiting the institute as a whole and devoting my important time towards benefiting the state as well. Working in the Institute of National Importance, NIT Mizoram,
In these circumstances, the committee may plan to send me the complaint to receive protecting the identity of the complainant, and the reply can be submitted by me in a stipulated time as shall be fixed by the institute with clear documentary evidence for each future use. Again, this is to be mentioned that the verbal discussion in the meeting so called for may not be well justifiable in the absence that what communications will be held between the members of the committee and me may not be clear to the concerned. Lordship, in this particular communication, I was noticed for a single day to appear before the alleged fact-finding committee, Lordship, alleged fact-finding committee. So thereafter, Lordship, the meeting was convened, and unimpugned order, that is at page number 29, Your Lordship. Page number 29. Page number 29, the next two, Lordship.
Yes.
This is, Lordship, this order date 31st January. I was first summoned on 29 January, and communication continued till 30th, Lordship. And 30th was fixed for the fact-finding committee meeting, Lordship. And basing on that, this particular order was issued, Lordship. I'm reading, Lordship. Pursuant to the decision of the competent authority of the institute, which is in line with the multiple complaints received from the research scholars against Dr. Vijayananda Mohanty, Associate Professor, Department of Civil Engineering, NIT Mizoram, regarding verbal and mental harassment to the PhD scholars in Department of Civil Engineering. A disciplinary action is hereby taken against Dr. Vijayananda Mohanty, Associate Professor, Department of Civil Engineering, NIT Mizoram, as under, number 1, Dr. Vijayananda Mohanty, Associate Professor, Department of Civil Engineering, NIT Mizoram, shall not be allotted any new research scholar for the next 3 academic years or till further orders, whichever is earlier. Number 2, Dr. Vijayananda Mohanty shall refrain from causing such mental harassment to his research scholars and must not threaten any of the research scholar. Number 3, if the institute receives further complaints against him, stern disciplinary action may be taken, leading to even expulsion from the institute. Now, see, the main reason of the challenge is that this particular order, even if it is to be issued, must be initiated as per proper forum, Your Lordship, proper channel, under the CCS conduct rules, Your Lordship, like memorandum of charges and a so-called notice, Your Lordship. Without doing so, Your Lordship, in this limited one day, short day, this particular order was issued, Your Lordship. So, my humble prayer is that during the pendency of this particular petition, Lordship, this order may kindly be stayed, Your Lordship.
This is that he shall not cause mental harassment and all that. It's okay. We'll give them a chance. You know who the council is, because the nature of the order, we'll have to see. So now what's happening? Action has been taken against him? Any
Lordship, page number
proceeding?
70, yes.
Disciplinary, this
Yes,
thing is
it's
going-
about to
then
initiate.
Then let that be initiated. He'll be given a chance to reply.
Lordship, my further prayer is that,
You see,
Lordship,
because at
this
this stage, we don't know what the complaint is, but if he's, the only thing is he should not be given a research distinct student. So for the next 3 years, that we will see when this thing matter is disposed of, along with the writ petition. 3 years is a long time. It will be
Lordship,
now. So
yes.
we'll give them a chance.
it's in fact a severe punishment, Your Lordship, without having procedure. So, Lordship,
So,
continue.
no, I'm seeing Mr. Caesar Ramchana. You are representing this thing.
Yes,
So let him accept notice,
yes, Your Lordship. I
isn't it?
received instruction for.
So cancel the order, Mr. So-and-so, learned counsel for the petitioner, full stop. Then Mr. Caesar Ramchana, learned counsel, accepts notice on behalf of the respondents. In view of the above, notice is said to be complete. The learned counsel is to file their counter affidavit for the respondents, is to file their counter affidavit within
2 weeks, Your Lordship.
3 weeks. What about the submission made by him for stay of the order dated so and so? The learned counsel
That
for the
may not-
petitioner has prayed that the order dated
29.
31/1/2025 may be stayed.
Regarding that portion, Lordship, if I may be allowed to submit, that may kindly be taken up in the next court date, madam. In the
Okay,
meantime, I'll obtain
maybe-
instruction on that issue also, madam.
Lordship, for that interim prayer, may kindly be listed after 2 or 3 weeks. No, sorry, 2 or 3 days, Lordship.
See, the main thing in this is for the next 3 academic years, okay, till further. So next 3 academic, I think in 3 weeks, this can also be looked
My
into,
lord.
okay. The Learned Counsel has prayed for an interim stay of the order dated, okay, 31st January 2025. So, the Learned Counsel for the respondents has prayed for time to get instructions regarding the said interim stay. In view of the above, this is a matter after 3 weeks for the Learned Counsel to file the counter affidavit and get proper instructions regarding the prayer for interim stay. Yes.
Obliged, Your Lordship. Evening.
Order, item 9.
Wait, please, Lordship, as per the last order, notice upon respondent number 3 is still awaited, my lord.
Who is respondent number 3?
My lord, he's the driver.
Is he necessary?
No, my lord, he's not necessary party. Yes, my lord.
Must be just a pro forma.
Yes, my lord.
Who is the one representing 1 and 2? Counsel for 1 and 2?
Mr. Jonathan, my lord.
He was here?
No, my lord.
Then see, in the next court date, you can pray for striking of the name of respondent number 3,
Yes, my lord.
isn't it? Mr.
Arlel Watfell.
Arnold Watfella, Learned Counsel for the appellant is present, while none appeared for respondents number 1 and 2. It is also seen that AD card from respondent number 3 is not returned till date. In view of the above, list the matter after 2 weeks. Yes.
Item 10.
Yes, this is for how many days?
This is an application for continuation of delay of 1,800.
1,000 something days.
My lord, yes. Airship certificate was issued without public notice, my lord. No notice was given to us.
So, who are the respondents? Okay, respondents?
My
You are-
lord, we just filed our power last week and
okay.
given 1
All
week
the
time.
respondents?
Yes, sole respondent.
All the respondents? How many respondents? 1?
Just
okay,
one.
for
One,
the sole.
yes.
Okay. Then we'll give them time.
My lord.
Heard Mr. L.H. Lianshima, Learned Senior Counsel, assisted by Ms. Ruth Lalwatfeli. Heard Mr. L.H. Learned Senior Counsel for the applicant / appellants, assisted by Ms. Ruth Lalwatfeli, Learned Counsel. Along with Mr.
Lalsangi Maralte.
Lalsanki Maralte, who submits that they will be representing the sole respondent and have they filed their PAR? And will be filing their PAR within the course of the
Already
day.
filed.
Okay, so it will be, then you don't have to mention that, so who submits that, they will be appearing on behalf of the sole respondent and has prayed for time to file their written objection. In view of the above, list after
2 weeks, my lord.
2 weeks.
Obliged.
Yes.
For hearing, item 11.
Yes, we are there.
Your Lordship, my senior counsel went to the toilet. Can you wait a little bit?
Pardon?
She went to the toilet, but don't.
Okay, yeah, she's here, she's here. What about the counsels for the respondents? We had heard this matter, and then we listed for further hearing.
Yes, Your Lordship, yesterday this matter was heard in part. This matter was heard in part, and my learned friend was instructed to produce the WPC that was filed earlier,
Okay,
and to see whether she have made a prayer for Section 34.
okay. Yes, yes. Now I'm recollecting.
It's Section 34.
23(1).
Because Celestium in interest, we do not have any issue. The only
Yes,
issue
yes.
that we can,
Wait, I'm recollecting now.
yes.
So, what is your prayer portion? Yes, can, Ms. Jatendra, tell me.
The prayer portion is the,
Call issue directed.
it is in page 9.
Why the land compensation under LA award so and so, and in award number which are bound to but shall not be dispersed. Land compensation which is in custody. So you have prayed for the land compensation.
Yes, my lord. Which was awarded under LA Award 1 of 2012.
So that should also include the solatium and the interest.
It can be included.
It should be included. That was not included. So if it was not included, you should have prayed for a review saying that this was not included in the award, not the amount. Did you mention the amount in your petition?
No, my lord, it is not mentioned.
So you should have approached the same court and said that this is not complete. The awarded amount is not this, it is this. Why file a fresh petition?
Because the petitioner better up by claiming Section 34.
Then,
No, but here solatium and interest amount is also already here in the
Yes.
award given to you.
Yes, but then in the in the instant case, there is, the case is upgraded and better up by making a claim of Section 34. Plus
But solatium
solatium in
is the-
interest.
Then, my lord, but regarding section 34, it is in the affidavit in opposition filed by the respondent number 1 and 2.
Solatium and interest under section, okay,
Section
interest in the
34.
delayed payment.
Yes,
Ah.
interest on delay payment. Then it is in annexure number 5 and number 1. It is in page 7 of the affidavit in opposition filed by the respondent number 1 and 2.
Okay, let's see. So
Then it is
their
regarding,
main ground for delay payment is because of the case that was pending against them, isn't it?
yes, that was kind
Must be, what other ground can they have? Affidavit dated? Counter affidavit dated?
counter affidavit dated. It's not mentioned what I have.
Is it 30th
received.
April 2024?
Yes, might be.
Affidavit in opposition on behalf of respondents number 3 and 4.
No, 1 and 2.
1 and 2. Yes, okay.
Then annexure number 1 of the affidavit in opposition. This is the appeal against
Judgment,
appeal against the order of special judgment PC Act dated 4/12/2015 in criminal trial number 1887 of 2015. I was being discharged from my church level in criminal trial number 1887 of 2015. And then after that in page number 8, then 2015 also they did not file any appeal against that order. Then 2016 also, the Kala sent the state government to appeal against the order of special adjustment PC Act dated 4/12/2015 in criminal trial number 187 2015. Then at this time also they did not file the appeal. Then in 2012, annexure number 3, page
Wait,
9.
I don't think we are on the same page.
Annexure number 3, page 9.
Annexure, wait, you're reading from, see,
I'm reading from the affidavit in opposition filed by the
filed
respondent
by
number 1 and 2.
respondents number 1 and 2, isn't it?
Yes, my lord.
So there's one annexure number 1, which is a judgment of the court. And then there's a check receipt on the receipt. 1 minute, wait, please. So you're talking about the first, there were 2 counter affidavits.
Yes, my
filed
lord.
by this thing, the respondent number 1 and 2. So you're talking about the first counter affidavit, which is dated 23rd February 2024. Yes, now we're on the same page. So annexure number 1 is the appeal.
Is the
Advice to file an appeal.
yes.
Then
But
annexure
they,
number
but
2.
they, but they did not file any appeal. Then after that, 9 March 2016, the Kala sent again to the government to file an appeal against the order dated 4/12/2015 in criminal trial number 187 of 2015. Then on the month of June 12, 2016, the Kala again sent he again forwarded the copy of judgment to the state government. And at this time also, they did not file any appeal. Then in 2021, March 25th, it is in annexure number 4, page 10. Then the Kala again sent the state government to regarding clarification of appeal against the order of special justice PC Act dated 4/12/2015 in criminal trial number 187 of 2015. Till that they did not file any appeal because of this, because they are because of this letter, correspondence letter, the Kala had failed to pay compensation to me because of that. Section 34, interest on delay payment is attracted. Yesterday, my learned friends say that it is not attracted, but because of the state government delayed the delay payment of compensation to me, then Section 34 is attracted.
Okay, that's your prayer. What about annexure 5? Who is Lal Rundiani? Annexure 5, page 11. Who is this?
Lal Rundiani is the wife of the beneficiary, Lal Chona.
Okay, the present petitioner.
Yes, present petitioner.
Okay, what did you say here?
During the pending, Lal Chona was died.
So you
And
have prayed for this thing, recovery of 9 lakhs something, isn't it?
Yes, for the disbursements of the 9 lakhs something.
Okay, this is 23rd 11/2022. Okay. So this 9 lakhs was given to you?
Yes,
now
my lord.
you have prayed for under 34 for delay payment, is it?
Yes, my lord.
Yes, okay. Yes.
Your Lordship, first of all, before I start, yesterday we already have.
Yes.
But then I just want to
What's
point out,
34,
Your Lordship, here there is no supplementary application for Lal Sona because Lal Sona passed away on 5/11/2021. Now, till date, the name is in Lal Sona. It should be substituted because the writ petitioner now.
When was the writ petition filed?
2023.
2021, and the
2023, this matter.
this matter is 23,
And-
but
When did she pass away?
2021.
5/11/2021.
Then that
And-
person cannot file.
And I don't know who have put the signature on this affidavit before oath, on oath.
No, Representative Baila Rundiani.
Then-
It is
then
represented
it
by
should be-
the Rundiani, and the Rundiani had put her signature.
Then it cannot be in his name, no?
This is a serious.
Because everything is in the name of Lalchona, and she did not obtain any heirship certificate because the land was already been acquired by the railway.
Your Lordship,
And
this
there
is
is
a
no way
mis-
of obtaining the heirship certificate if the immovable properties
It's
is
okay.
inexistent.
Heirship certificate is not required, but if it belongs to your husband, no, you should say that since he has passed away, you represent C. Okay, wait, let's go. Here also in the in your writ petition, it is filed by a late person, Lalson Liana late.
Yes,
You should make it represented by his wife.
should be substituted.
Not substituted by his wife. In a writ petition, which it did come to the notice of this court also that time. Anyway, you this thing make the correction because nothing is in the writ petition. Here, if you look at the copy, it is Lal Sonliana, late son of so and so. Writ petition is in the name of the late so and so. But then a late person, a dead person cannot be this thing. You can say represented or substituted by what?
Unless it's a fresh writ petition.
No.
My learned friend will
fresh
have to make a
petition is not
substitution
re-
application, Your Lordship.
You file an IA.
Yes.
Fresh writ petition is not required. You file an IA so that you represent your late husband. We will allow, and then we'll this. We've already heard the matter, no more or less, isn't it?
Yes, my lord.
Then in the next date, I think we'll say hearing is complete and we can this thing. But
my
then
lord.
let that formality be there.
Yes, my lord.
Because then it won't be appropriate.
There will be misconceived
So,
of justice.
heard Ms. Jacinta so-and-so who submits that she may be allowed to file a application, interlocutory application to represent the petitioner since the petitioner has this thing passed away. Praise the Lord. List in the next week?
Yes, my lord.
Okay, list in the next week. We'll dispose this off.
Yes.
It didn't come to the notice of this court also, because the petitioner is late.
Yes, my lord.
Okay, yes.
Item number 7.
Yes, really.
7, who is the counsel?
The
Who is
council is
appearing?
not present. He's still not coming, my lord. May the matter may be taken up tomorrow or
Okay. Mr. Lalpian Fela Chongtu, learned counsel for the petitioner is present, while the learned government advocate, Miss
Caroline.
Caroline K. Lamoipui, is said to be on legs in the other court. In view of the above, list this matter tomorrow's date. Yes.
Oblige, my lord.
Part 2, item number 1.
I think we had a time being matter somewhere. Anyways, Part 2, number 1, writ petition. Who is appearing for the petitioner? Who had prayed that this matter be listed today? previously we had prayed that this matter be listed on 1606.
Yes, my learned friend, I'll just call him, Your Lordship. He's waiting
He's
for this
around?
item. Yes,
He
he's
was
around.
waiting for this item?
Yes,
Okay.
it's a small issue.
What's the matter about? Okay, it's regarding the date of taking possession of
Possession,
the
yes.
landed property.
And whether they are entitled to Section 34 interest or not.
Okay. From the date when they took possession of the landed property till the payment, is it?
Yes, yes. The basic case is that they have sought an RTI, and the RTI, it was the first answer, but then they made a corrigendum to that RTI, the state, and subsequently filed an affidavit, additional affidavit also.
So nothing, besides that, nothing else? That's the only issue in
That's
this
the only
petition?
issue, small issue.
If not for that, the awarded amount was given? Where is it? Yes.
Please, Your Lordship, I apologize, I was in the other
That's
court.
okay.
This matter pertains to the petitioners claiming an interest under section 28 and 34 due to the acquisition of their lands. My lord, the petitioners' land were required for public purpose, and a notification under section 4(1) of the LA Act was issued on 13/8/2013. That is at page 46 and 47. And thereafter, the respondents have also made a declaration under section 6 of the LA Act, dated 4/2/2014. That is at page 49 to 50. And thereafter, the petitioner, being unaware as to the exact date of possession by the respondents,
Whose land is it?
the petitioners, my lord.
Your land?
Yes, there are 165 petitioners, my lord.
Okay, so you're not staying within that land?
No, my lord.
You don't know when it was acquired?
No, we know it is when acquired, but the exact date of possession was disputed. So to clarify this matter, one person by the name of H.C. Kapchunga of New Serchi had submitted an RTI application to the respondent, wherein he had proposed a question whether the certificate of handling of taking over the acquired land to the acquiring department with its copy has been made or not. This question has been made in question number 6 of his application. And the application was replied by letter dated 9/3/2018, wherein the State Public Information Officer, Project Implementation Unit, Mr. Kelal Biakthanga, who is the Executive Engineer of Procurement in the PWD, has replied that no such certificate is issued. So the certificate of handling and taking over possession of the acquired land of the petitioners was not made by the respondents.
Oh, okay.
And yes. And thereafter, the petitioners were paid compensation in terms of the award. And the award, although included in the
Now, where's the award page?
page 52, my lord. Page 52 to page 70. This is a chart showing the amount of compensation payable to the petitioners. However, no such date has been mentioned in the said draft award. And to clarify this matter, Mr. Arnold Nunpuya, who is the previous counsel, had submitted an RTI application to clarify the date by way of an RTI application. And the state letter was replied by a letter dated 6/8/2018. If I may read, my lord.
Page?
Page 71, my lord. Date, month, and year of passing the draft award number 3 of 2014 to 2015. Construction of Labung 2, Korpuichwa Road under Mizoram State Roads Project 2. Answer. The draft award number 3 of 2014 to 2015. Construction of Labung 2, Korpuichwa Road under Mizoram State Roads Project 2 was passed on 8 May 2015. So the date of the award, as can be seen from this RTI reply, is 8 May 2015.
Okay.
And since the petitioners were paid compensation only on 31/5/2016, that is at page 73, my lord. Actual payee receipt 31/5/2016, though the award was passed on 8 May 2015. The state Arnold Nunpuya had proposed another question to the respondents herein at page 74, my lord. This is the RTI reply dated 5/10/2018. The information requested: number 1, date of taking possession for construction of Labung to Korpuichwa Road under Mizoram State Roads Project 2. Answer. The date of taking possession for construction of Labung to Korpuichwa Road under Mizoram State Roads Project 2 is 13 August 2013. So, as per this letter, there is a delay in payment of compensation for approximately 2 years and 9 months. 2 years, 9 months, and 90 days. And being aggrieved, the petitioners had approached the Special Land Acquisition Officer, Public Work Department, PWD. This is the respondent number 4. By way of a representation dated 8/11/2018. The representation can be seen from page 75, my lord.
Yes.
It was submitted on their behalf by the previous counsel, Mr. Zaud Swana. And since there was no fruitful result of the representation, and since the representation has not been answered, this writ petition has been filed by the present petitioners, so that an interest under section 28 and 34 of the Land Acquisition Act may be paid to them. And
Why 28 additional, this thing was given later? Why 28?
my lord, 34, I apologize, only 34.
Only 34, isn't
madam.
it? Huh?
Yes.
Okay. Okay, that's it.
Yes, and the state have submitted an affidavit later on, the affidavit in opposition. wherein page 7 of the affidavit in opposition, my lord.
Wait, affidavit in opposition dated
Dated,
8 August 2023, is it?
yes,
No.
my lord. In my copy, the dates and the months have been left blank.
Wait, let me just see.
There is only one affidavit from the state respondents, my lord.
No, this is the additional affidavit. So
Affidavit in opposition on behalf of the state respondents in the opposite writ petition.
Filed on 11 May 2020.
Filed on, it appears 11 May 2020.
Yes.
At page 7 of the
Oh, yes.
affidavit, this is the corrigendum regarding information required under the RTI Act. If I may read, my lord.
Yes.
Dear sir, with reference to the above, I have the honor to state that a corrigendum have been made regarding this office letter number so and so dated 5/10/2018, in which the date of taking possession for construction of Labung 2 Korpuichwa Road was given as 13 August 2013. It may be mentioned that we have given the date of issuance of notice under section 4 of the LA Act 1894 by mistake, and that could not be taken as the date of taking possession of the land, as the land has not yet been acquired during that time. I therefore would like to kindly mention that the date of taking possession for construction of Labung 2 Korpuichwa Road is the date in which an agreement was signed with the landowner. So the date have not been specifically mentioned, but they have enclosed the agreement at page 8. And it
The
appears
agreement is dated?
the agreement is 31/5/2016. So, as per their affidavit, there is no delay in payment. But, my lord, if your lordship may go to the agreement, the agreement is only with regard to whether the petitioners, if they have received more than the acceptable assessed value or the excess amount is given by the state government, it shall be returned to the government immediately. And this agreement does not talk anything about possession of the land. And one thing very surprising is that though the petitioners have, to their counsel, have submitted an RTI, and the same was answered on 6 August 2018, 6/8/2018. And though a representation has, 5/10/2018, and though a representation has also been submitted on 8/11/2018, wherein the respondents have not taken any action, and only after filing of the instant writ petition, the petitioner had made a corrigendum in their RTI reply. And so far as my knowledge is concerned, the power of review is not vested with the state public information officer. And if any mistake is made in the answer, they can go for an appeal. But only after the writ petition has been filed, they choose to amend their reply to the RTI application made by Mr. Arlan Nunpuya for their own benefit. And the petitioners have also submitted an affidavit in opposition with regard to this, wherein they have stated that this letter was never furnished to Mr. Arlan Nunpuya, and it
Which
was
letter?
this letter, this corrigendum letter,
Okay.
was never furnished to Mr. Arlan Nunpuya, and that it was only after the filing of this affidavit that Mr. Arlan Numpuya come to know of the same. And so, in my humble understanding,
Arlan Dunpuya is the petitioner.
Arlan Numpuya is the counsel for the petitioners.
Okay.
He
Okay.
used to be the junior to Mr. Zulfana, who passed away. And in my humble opinion, my lord, the respondents are uncertain as to the date of taking possession. And in this regard, I would like to
So since you're the owner of the land,
yes, my lord.
you should know the date when they took possession of your land.
Yes, my lord.
Even you don't know when they took possession of your land.
My lord,
You're not saying that they took possession on a certain date. You have no
My
stand
lord,
on that.
if your lordship may kindly,
If it's your land,
if your lordship
if
may
you're in
kindly
ownership,
speak,
you
yes.
should be knowing when you
Yes.
were no longer in possession of your land.
My lord, with that regard, if I may take your lordship to the notification, the declaration dated 49, page 49 to 50 of the writ petition.
Okay, page 49 to 50. Yes, page 49. Notification under section 4.
Oh, I apologize, my lord. Page 46, my lord. Page 46. Notification dated 13/8/2013.
You should also have a date. This is when they took possession, because I'm the owner of
Yes,
the land. I
my
know.
lord, I will explain, my lord. Page 46, paragraph number 3.
Yes.
All persons interested in the said land are hereby warned not to obstruct or interfere with any surveyor or any other persons employed upon the said land for the purpose of the said acquisition. Any contract for the disposal of the said land by sale, lease, mortgage, assignment, exchange of the status of past or otherwise, or any outlay commenced or improvement made therein without the sanction of the collector will, under clause 7 of section 24 of the said act, be disregarded while assessing compensation for such part of the said land as may be finally acquired. So, to the opinion of the petitioners, since a restriction has been imposed upon them and they were not allowed to make any sale, lease, mortgage, assignment, exchange, or disposing of their land parcels, to the petitioners, the date of taking possession is 13/8/2013. And this can also be clearly seen from the RTI reply, wherein they have stated that the land was acquired. The land was taken over possession on 13 August 2013, before the amendment, before a corrigendum has been issued.
This is notification under section 4.
Section 4.
1.
Yes. Though it is published in the form of a notification, we are restrained. We are not allowed to do anything
Let's
from
see
the
the
date forward.
notification under LA Act. What are the contents of the notification? Section 4(1).
Publication of preliminary notification and powers of officers thereupon. My lord, should I read? Sub number 1. Whenever it appears to the appropriate government that land in any locality is needed or is likely to be needed for any public purpose or for a company, a notification to that effect shall be published in the official gazette and into daily newspapers circulating in that locality, of which at least one shall be in the regional language, and the collector shall cause public notice of the substance of such notification to be given at convenient places in the said locality. The last of the dates of such publication and the giving of such public
So
notice.
just come to 2, that is a notification. Huh? Then
Thereupon
2.
it shall be lawful for any officer either generally or specifically authorized by such government in this behalf and for his servants and workmen to enter upon and survey and take levels of any land in such locality, to dig or bore into the subsoil, to do all other acts necessary to ascertain whether the land is adapted for such purpose, to set out the boundaries of the land proposed to be taken and the intended line of the work, if any, proposed to be made thereon, to mark such levels, boundaries, and line by placing marks and cutting trenches, etc. Where otherwise the survey cannot be completed and the levels taken by the boundaries and the line mark to cut down and clear away any part of the standing crop, fence, or jungle. Provided that no person shall enter into any building or upon any enclosed court or garden attached to a dwelling house, unless with the consent of the occupier thereof, without previously giving such occupier at least 7 days notice in writing of his intention to do so. So, after notification, possession can be taken by the acquiring authority.
No, I'm just seeing whether this notification can be also construed as being in possession. That's what you're saying, no?
Yes, my lord.
So the language
Yeah.
and the, this thing, if it's a notification first under section 4, then can we look at this notification and
Yes.
presume that they have taken possession?
Yes, my lord.
You'll have to see read this thing.
The wording is a bit different from other preliminary notifications, my lord. So, to the opinion of the petitioners, this means that they have directly taken over their land, since restrictions have been imposed upon them, and that they were not allowed to.
Within 7 days.
Yes.
Anything mentioned about the 7 days?
No, my lord, because the possession certificate needs to be issued by the acquiring authority, but that has also not been done in the instant case, as can be seen from the RTI reply. And one more thing I would like to submit is that the respondents will be doubting or will be arguing that possession has not been taken on this 13 August 2013, and there are some mistakes. However, my lord, the petitioners are willing to accept the fact that there is an uncertainty with regard to the date of taking over possession. And in such a case, my lord, the petitioners would like to rely upon the case of Lilagos versus State of West Bengal, decided by the Honorable Apex Court, reported in 2004, Volume 9, SCC 337. Paragraph number 19, my lord. Even though the authority in Sri Vijay Cotton and Oil Mills Limited appears to support the claimants, it is to be seen that apart from mentioning section 28 and 34, no reasons have been given to justify the award of interest from a date prior to commencement of the acquisition proceedings. A plain reading of section 34 shows that interest is payable only if the compensation which is payable is not paid or deposited before taking possession. The question of payment or deposit of compensation will not arise if there is no acquisition proceeding. In case where possession is taken prior to acquisition proceedings, a party may have a right to claim compensation or interest, but such a claim would not be either under section 34 or 28. In our view, interest under these sections can only start running from the date the compensation is payable. Normally, this would be from the date of the award. Of course, there may be cases under section 17 whereby invoking urgency clause possession has been taken before the acquisition proceedings are initiated. In such cases, compensation under the Land Acquisition Act would be payable by virtue of the provision of section 17. As in cases under section 17, compensation is payable. Interest may run from the date possession was taken. However, this case does not fall into that category. In view of the above, we hold that the violation would be summed up.
So why are you reading this?
Because, my lord, this says that the section 34 would run from the date of the award.
Yes. So 34 will arise from the day the award is given.
So, so far as there is an uncertainty with regard to the date of taking possession, the petitioners, it may be taken from the date of the award in this case as well, my lord, in the present case.
Then the date of the award is when?
The date of the award is 8 May 2015.
So 8 May 2015 to the day you received the award.
To the
That
day
is
we received-
2016.
Yes,
Dated 13/8/2013.
Hmm?
1 year.
1 year and 23 days, ma'am, to be precise.
This is not your petition. This is not what you have mentioned in your petition, but you're
Yes.
conceding.
Yes, in my petition, I want the date to be counted from 13 August 2013.
This is completely different.
Yes, however, since the state are disputing, I am willing to.
So, you get instructions on this? Or you're going to, this is something new during his submission?
No, Your
That
Lordship-
instead of so many years, we would like to do it here?
Your Lordship, in this respect, additional affidavit also is filed. But then this case is not applicable in the instant case. In as much as if.
Yes, but let him
Yes.
complete, okay. So he has conceded, I will not claim for 3 years, but I will claim for 1 year, some days, okay.
Yes.
Then, anything else?
Yes, my lord. One case, another case, 1976, volume 2, SCC 406, State of Madras versus KN Shanmuga Mudaliar and others, my lord. And this is a case where the Apex Court has upheld the interest from the date of the award. I'll start from paragraph number 4, my lord.
Yes, paragraph 4.
On appeal, the High Court affirmed the decision of the subordinate judge regarding the rate of compensation. The contention advanced on behalf of the appellant that as the land had vested in the government under the Abolition Act, the respondents were not entitled to compensation under Land Acquisition Act was rejected. It was observed that in the land acquisition proceedings, the government was stopped from denying the absence of any interest in the claimants whom the government had made parties to the proceedings regarding the date from which interest on the amount of compensation should accrue. The High Court found that there was no material on record to show that possession of the land had been taken prior to the date of the award by the land acquisition officer. Interest was accordingly directed to run from the date of the award. And the relevant provision would again be on paragraph number 6. I will skip paragraph number 5 because it's not relevant. As regards to the quantum of compensation, the High Court has referred to the previous decisions, which shows that the formula generally adopted is to pay 1/3 of the total compensation to the Mela Varamdars and 2/3 of the compensation to the Kudi Waramdars. In accordance with that formula, the respondent would be entitled to 1/2 of the compensation payable to the Kudi Waramdars. Both the subordinate judge and the High Court awarded compensation in accordance with this formula. No cogent ground has been shown to us as to why we should interfere with the concurrent finding in this respect. We also find no reason to disagree with the High Court regarding the date from which interest should run on the amount of compensation. That is, the High Court has found that interest should run from the date of the award. So, my humble submission is that if there is uncertainty or a conflict with regard to the date of possession,
Because
date
date of taking possession certificate has not been given, isn't
given.
it?
So,
That is under which section of the LA Act? Any this thing mentioned specific certificate has to be given based on the Act? Because you're saying that it has not been given.
no, my lord,
So is it required to give a certificate as per the Act or no?
my lord,
Because in the agreement, something is mentioned concerning the date of possession. Certificate of taking possession, is it mentioned in the Act? Since it is not made, so this should be applied. That is your prayer.
my lord, just 1 second.
If it's specified in the Act, it's a different matter. Then there should be a requirement. After declaration,
Declaration.
for to take possession,
After declaration, collector to make order for acquisition.
what do you
Then
want?
we mark out measure. Uh, 16 is the power to take possession, madam. When the collector has made an award under section 11, he may take possession of the land which shall thereupon vest absolutely in the government, free from all encumbrances. So, a certificate
So
of
that's why
possession.
if the date is not clear, therefore, it will has to be, if the date is not mentioned, then it has to be taken as the date when
Of
the
the
award
award.
was made because of section 11.
Yes, my lord.
That's it, I think, submission.
Yes, my lord.
Yes. Oh, this is very,
Your Lordship, a possession certificate is not specifically mentioned in the Act. However, this is crucial documents to for land ownership and property transaction. That's it. So in many cases, in some of the cases, they used to issue certificate, but in some cases they don't.
if not, then section 16, is it? If not, then section 16 of the Act,
Yes, Your Lordship.
it's mentioned. Oh.
Yes, what my learned friend have submitted, the authority is not applicable in the instant case. My learned friend have already taken Your Lordship to the facts. it is true that a corrigendum of the RTI is made, but then that is inconsistent with the agreement. My learned friend have only taken in part of the agreement that is signed.
Let's see the agreement.
Yes, it's in page number 8 of the affidavit in opposition of the state. The translated copy will be in page number 9.
Yes.
Yes. We have to read in whole, not in part, Your Lordship. This agreement for construction from Tabung, Korpuichua under the Mizoram State Road to Regional Transport Connectivity Project is signed between the representative of landowner and state government on today, that is 31st May 2016. Name of landowner, so-and-so. I'll come to the next paragraph. The above mentioned amount, so-and-so, will be handed over to the landowner by SLAO, PIU, PWD, and landowner will also hand over their land to the government. So this is on the date of execution of this agreement. Now, there is no denying fact. There is no deny from the petitioner that this agreement is never questioned. But in fact, they are relying on this agreement. So the agreement stated clearly that the landowner will also hand over their land to the government. It's very clear that on the date of signing of the agreement, that is 31st May 2016, the land was still in the possession of the petitioner. Now they are trying to take the benefit of the mistakes that was clerical mistake that was committed by the officials. Even though corrigendum and on oath affidavit is already filed in this behalf explaining the matter. But then the corrigendum as well as the affidavit will cooperate, will be in supplement to the agreement. Now the agreement, it's written in black and white, it's very clear that they will hand over the land to the government. They will. So the date of possession, it cannot be taken from the date of notification in this case. In some cases, it might be, but then not in this case. Because in this case, agreement is signed.
It's never on the date of the notification.
Yes.
Notification is usually to
And
inform.
here, I'll further
Yes.
proceed, Your Lordship. This agreement shall be signed only after clear explanation, without any force or misunderstanding or cheating. In case of amount received so-and-so, this my learned friend have already taken, and there's note. As per Rule 47, subclause 4 of Mizoram Land Revenue Rules 2013, 15% of assessed value of the house pass so shall be remitted to the government of Mizoram. So it's very clear.
Okay, so now what about the awarded amount? Has it been received by
Yes.
the petitioners? Already received?
Yes, Your Lordship. On the same date,
Okay, amount has been received.
The amount
Now they are
is-
claiming more, saying that it should be the sing interest under 34. Is it?
yes.
Yeah, okay.
Your Lordship, the actual pay receipt is on the next page, page number 10.
On the same date?
Paid by me, signed on 31/5/2016. Sealed by Special Land Acquisition Officer.
So it was paid on when?
31st
31st?
May 2016, the same date when the agreement
Okay,
was
on
signed.
the same date, huh?
Yes. So the question of section 34 does not arise in the instant case, Your Lordship.
2000, yes, okay. We'll make it a CAB, we'll pass the order accordingly.
Yes, my lord, just
Yes,
one more
anything-
thing.
Yes, please.
In the vernacular, it's more of like in the agreement, the petitioner will give the land to the government.
Wait, let's see the vernacular.
It doesn't talk about possession.
Your Lordship, it says that aram na ito in paltakin sorkar niya na aram alan bokang. So
it's
it
more of a
is
gift.
in future, it is in future
And
tense.
The agreement is also against the Land Acquisition Act 1894.
But that is never in question and is not challenged.
Anyway, Anything else?
No, my lord, that's all.
Yes, heard Mr. Zoram Thana, learned counsel for the petitioner. Also heard Mrs. Mary L. Kiante, learned government advocate for the state respondents. Hearing is concluded. Matter reserved for judgment.
Obliged, my lord.
For admission, items 5 and 6.
Okay, so this matter, you're saying it's a simple matter, you want it to be disposed of at the admission stage, is it?
Lots
Instead
if possible.
we'll admit it and we can listen for hearing also, up to you.
If possible, the two matters may be fully heard and disposed of.
Then we'll admit it and listen for hearing instead of at the admission stage. If you say that it's a simple matter. Because you see, sometimes when the matter is very simple, then it can be disposed of at the admission stage. But when it requires proper hearing, the usual practice, at least in the principal seat and this thing, is that it is admitted and then listed for hearing and then taken up for hearing. But if it's a small matter which can be disposed of at the admission hearing, it can be done. That's not difficult. But then it depends then on the counsel for the respondent. Yes. Does it require a proper hearing? Are you really going to oppose to the matter? Because if it says, if it is promotion is seniority come merit, then I think there are judgments dealing with that.
I have a judgment which is in my favor as well.
Okay.
So it will require.
Because seniority is usually considered
Yes.
if they acquire the benchmark. Because seniority come merit.
My learned friend is going to rely upon the congeniate bench judgment of this court, but which I will also rely upon the judgment of the Supreme Court.
Then does
I
it
think
require a proper hearing?
it needs proper hearing.
No, then we
Will you
will.
of the stand sought to be taken?
Then we will admit the this thing, and we can fix a date also for hearing.
Yes.
Isn't it?
Not
Then
if,
you
if
can-
it can be heard early,
okay.
because of the fact that one of the petitioners in 99 of 2024, she had already retired, left service on pension.
Okay. You see, because when it is for in the admission stage dispute, then it becomes an order. When it's in the hearing column, then becomes a proper full judgment. It's better if it's heard, isn't it?
Hearing.
Heard Mr. C. Ramzawa, learned senior counsel for the petitioner, assisted by Stephen Lal Rotsara, learned counsel. Also heard Mr. C. Lal Fogswala, learned counsel for the petitioner. Having heard the submissions made by the learned counsels for both the party, matter is to be listed for hearing on, give a date. When, give it any date when both of you are available.
Your Lordship, we are now in 17 June.
After vacation. Right? July.
After vacation, Your Lordship, or just before vacation, we have 1 week.
Give it a date, it's okay. Or you can make it after vacation also, no
One-
problem.
1/7.
Okay, list again on 1/7/2025. Okay, list on 1/7. Cancel the again. Yes,
For hearing.
yes, for hearing.